when the prosecution had far advanced its case before the court. I am told that they had called even the second prosecution witness. But today, the learned Attorney General tells us that on his own, he comes out and says that he negotiated with the parties without any court's involvement, and he intends to free. He has already entered a nolle prosequi, so he had freed them. The next question, or question 3, that I may want to ask. Transparency, as indicated in the press release, demands the learned Attorney General to explain to Ghanaians the principle of 60-40. Ladies and gentlemen of the press, once a nolle prosequi is entered by the Attorney General or the prosecution, we need not find out, and we don't need to find out questions. But he chooses to, if you read a press release, he chooses to justify why he had done that in the name of transparency. And that's why I say that transparency, as he had indicated in the press release, demands that he, the learned Attorney General, would explain to Ghanaians the principle of 60-40. If you're talking about 5.7 billion cedis and you tell us that you have retrieved 800,000 cedis, how can you say that that represents 60,000? And at any rate, is it a new policy directive, or when did this come into Ghana? When was this introduced into our criminal jurisprudence? What happens to the remaining 40%? To him, the Attorney General, today we heard him say that the 60-40, we can forget about the 40%, because he uses the proverbial theft of 6 goats, that if 2 or 4 are recovered, then he can allow the 2 to go off, meaning that the 40%, what the Attorney General in his jurisprudence is telling Ghanaians, that he would let go the 40%. That means the 40% should go with. The press release makes reference to 60% recovery threshold as a benchmark for reconsidering prosecutions. When was this policy introduced, and under what legal authority? Was this benchmark made public or debated in Parliament? Was it quietly introduced post-2024 to lower the standards of accountability? For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from Dr. Dufo constitute 60%. How did the Attorney General review the amount from the 5.7 billion to 1.2 billion by a mere administrative fiat? The best we heard from him today is to make arrangements for the amount to be paid into public fund. One would have thought that he would wait until the amount, the recovery that he's talking about, would have been paid into the coffers of the state before thinking of nolle prosequi. Did the Attorney General consider Section 35 of the Courts Act at 459 in coming out with the 60-40 threshold? For the avoidance of doubt, Section 35 of Act 459 states, and for the lack of time, let me paraphrase, that if you want to make any restitution in such cases, you consider Section 35, which says that a person may plead to a lesser amount, and then you can then enter a nolle prosequi or file anything for the court to consider. And if the person fails to do that, then the person could be punished. When I finish, I can give you a copy of what I'm holding, and then you can have the full text of Section 35 of the Courts Act. Why did the Attorney General turn a blind eye on the above institutional provision? Why would the Attorney General also look at the principle of the plea bargaining agreement? Under our section, that is the Criminal Procedure Act, Act 30, as amended by Act 1079, and I have a copy of the Plea Bargaining Act as amended. The Attorney General is telling us today that he did not even look at the Plea Bargaining Act. He didn't look at the Courts Act. He didn't look at the Plea Bargaining Act. The process was not supervised by any court. And what he is telling us is that he himself, on his own, so motu, got the parties and negotiated with them. Where did he get the figures from? When the prosecution had already started this prosecution, and I have the facts as presented by the prosecution, and those who are interested, I can give you copies, you make copies of that. And when we had done this, why did the Attorney General ignore this, and why didn't he tell us anything from this? Why was the accused person not convicted, even when he agreed to pay 60% in line with plea bargain agreement under Section 35, or under the plea bargaining agreement, or under Section 35 of the Courts Act? For plea bargain to be accepted by the court, there are a lot of options opened to the parties, including conviction. However, any such process must be supervised by the court. In the learned Attorney General's nolle prosequi, he just enters. Nobody would have thought that we would ask him questions. But because he chooses to say that he wants to be transparent, we want him to be more transparent and answer the questions that we are asking him. So how the Attorney General allowed the accused person to walk free without a conviction and without supervision of the process by the court, that definitely cannot be under a plea bargain agreement, as he had himself said. And if it is not a plea bargain agreement, and it also doesn't come under Section 35 of the Courts Act, where did he get the 60%, and how much has he collected? Today, he tells us that he's going to make arrangements for the monies that have been collected, about 800,000 to be paid into government coffers. The learned Attorney General has obviously forgotten the theories of prosecution and punishment. In fact, if he had thought of it, he would have appreciated that deterrence is one of the theories that we take into consideration in punishing people. Ladies and gentlemen, as we conclude, we would like to take this opportunity to call on all voices of conscience in our society, especially lawyers, judges, civil society, clergy, traditional leaders, and you, the press, to sit down and watch, and not to sit down and watch on unconcerned, whilst the Attorney General, trusted with the office responsible to uphold the rule of law, on the contrary, pursue rather a destructive agenda to the detriment of the good people of Ghana. We therefore call upon any interested party, the Parliament of Ghana particularly, its Select Committee on Constitutional and Legal Affairs, to summon the Attorney General to answer these questions publicly. The Legal Counsel and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Dr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety. Let it be known that justice must not only be done, but it must be manifestly seen to be done. Thank you. If there are some questions, I will take it. If you have any questions, I will take it.
Do you have any intention to hold the minister before?
No. Well, we are rising, so that won't happen. I told you to come and but I will not see it.
Sorry.
Yeah.
Oh yes, but the questions first.
You holding the minister before the House to answer questions.
Yes, it's one of the actions that we had him this morning speak to the press, and we said twice to answer what he's doing, and we think that he's not doing the right. So once we've come out with this press conference, we have to hold him accountable. We see, he gives an impression that the system that he made is not helping to retrieve monies, and that monies are going to waste. But I will get in the same financial sector crisis, I will cite the case of the Crowell and Associates in Unibank. When the court supervised, the court said that they should pay 1/3, and they paid 90 million cedis upfront before. And when he was not able to pay the rest, the person is convicted and is in jail now. So it's not a matter of saying that I won't put people before jail. There are laws in this country, and deterrence is also right, so that if somebody does the wrong thing, you punish him. We hear the Attorney General also citing the Beige capital issue now as an example, which is a clear indication that he doesn't even plan to take the case further, probably appeal against the decision of the court. It means that he is satisfied. And he also gives an impression that he is not perturbed about financial crimes. And he equates civil actions or civil threshold to criminal threshold. And I think he is wrong.
You need support.
You're welcome back from Parliament, where the Minority Caucus were holding a presser, essentially addressing the decision by the Attorney General to discontinue the case against Mr. Kwabena Dufo. Essentially, what the minority is saying that if the AG fails to rescind this decision, they might be compelled to head to court